Hey, good morning, everybody. It's Beau from FinTech Law back with our next video. And today we're going to talk about private funds. Okay, I have a lot of clients that come to us with interest in launching private funds. Some of these clients are established investment advisors that are maybe already managing separate accounts. Others are interested in pursuing specific strategies within a fund structure that maybe isn't as scalable in a separate account. And then some of our clients are new managers, right? And the first product that they want to launch out the gate is a private fund. There are some benefits to that, which we won't go into too much detail today, but one of the benefits is depending on your assets under management, what state you're in, you may be exempt from registration both at a state level and the SEC level, which can be helpful, right? It makes your operating requirements and costs a little bit lighter. So what I thought I'd do today is talk about some of the key points that I often discuss with our clients and things that are important to think about before you decide to launch a private fund. So the first thing I want to hit on is formation, right? You have different options. You have options as far as what state you want to form in and also what type of entity you want to form. So the most common state is Delaware. That's obviously the 800-pound gorilla when it comes to establishing almost any type of corporate structure. Delaware's got great law, well-established, good court systems. So that's usually the preferred choice, not only for the asset manager sponsoring the vehicle, but also for investors. Investors are comfortable with it. And one of the key things I tell all of my clients when we're talking about any investment product is know your audience, right? Know your investors, know what their expectations are, know what they're familiar with, and play in their space, right? If you start to do things that are different than they've seen before, that may give them pause, that may require them to do additional due diligence. They may question kind of if you know what you're doing, even though you might. They may question it, right? So know your audience, know what they're comfortable with, and in many cases, that's going to be Delaware. So generally speaking, in Delaware, you have a couple of options. Historically, most funds were formed as limited partnerships. The nice thing about that is the law is well established. The downside of it is technically the general partner has unlimited liability in the partnership. Now there's a way to get around that. You could actually form a separate general partner that is a limited liability company, which helps to block some of that liability. But that requires essentially three entities. You need to form the fund, you need to form the general partner, and then the general partner would engage usually the asset managers, the investment advisors. So it's kind of a three-part deal here, which is fine. Again, that's historically the way things were set up. Lately, what I've seen and what I tend to recommend to a lot of my clients, depending on their investors, their strategy, is to use a Delaware LLC. The nice thing about the Delaware LLC, again, good favorable tax treatment, nice law wrapped around that type of vehicle. It also gives the manager limited liability, so you don't necessarily have to go out and create that separate management entity. The downside is it could be, depending on what state you're in, if it's Delaware or others, it may be a little bit more expensive, but we're talking relatively small amount in the grand scheme of things, right? We're talking hundreds of dollars. We're not talking thousands or tens of thousands of dollars to form. So Delaware limited liability companies have become more popular lately, but there are other states out there that also have great options. And sometimes, again, know your audience. If most of your investors are going to be in a particular state, if you're in a state that has good corporate law, another state that I like to use is Nevada. There are people out there who like to use Wyoming and South Dakota and other jurisdictions which tend to be kind of pro-business. There are options, right? So you don't have to go with Delaware, but it's something to consider. Once you've kind of decided where you want to form the entity, and your legal counsel should be able to kind of walk you through the pros and cons of that, the next most critical piece is to make sure you know your strategy. The number one area where I see these projects and products get stalled is when it comes to the strategy. So the asset manager shows up, they think they've got their strategy in mind, right? But maybe they haven't put that much thought into it, and all of a sudden they want to keep changing things. They want to tweak things. They want to go from being a venture capital fund to a PE fund. They want to, do different things. And all of that is going to, one, delay the project, and it's going to drive up your legal costs. I mean, as lawyers, we're not in the business of helping you build your business plan. We're helping you execute your business plan the best way possible. And so it's important, if you're working with us, to make sure that you've got a clear idea of your strategy. If you've got some documentation around that, maybe you've got a slide deck you've prepared, maybe you've got some other internal documentation, maybe the strategy is based on another product, maybe you've been running this in a separate account or some other vehicle, and you want to kind of leverage some documentation for that. Any of that can be really helpful when setting up the entity here, the vehicle. So we can take that documentation. It helps us to define the strategy. And then once we know the strategy, we can get the risks, right? Because the risks need to be customized to the strategy. You shouldn't be doing boilerplate risks. It really needs to be tailored to the strategy so that the investors have a clear indication of not only how you're going to manage your money, but what the risk is as part of that management. So, probably the three most important things to think about when you're forming your strategy, what are the target assets you're going to be focusing on? Make sure you've got those well defined. It can be pretty broad. You could have a go anywhere, do anything fund. That's fine. It's going to make your strategy disclosure a little bit longer and your risk disclosure longer, but that's fine. But if it's going to be a more focused product, make sure you've got that target assets well defined. Talk about how you're going to actually invest in products, right? How are you going to screen out products? What does your investment process look like? What factors do you consider? What factors do you consider both for going into an investment and also getting out of an investment, right? So it's helpful to let investors know like when you might sell or let go of an investment. What are the criteria around that? So make sure you've got that well defined. And then if you have any specific performance goals or targets or things like that, again, not required, but if it's part of your strategy, let's get it in there. Let's talk about it. So once we've got that investment objective and strategy built, we can then turn to the risks, all of which is going to be included in your PPM. The other important document when we're forming a new private fund, in addition to the formation documents and the PPM, which is where your risk and strategy and fee information is included, is the operating agreement. And the operating agreement can be very critical. You want the operating agreement to be customized to the product, right? So don't just have like a general boilerplate operating agreement. If you're a hedge fund, you need a hedge fund operating agreement. If you're a private equity fund, you need an operating agreement customized to private equity. If you're doing digital assets, again, that should be reflected like in the operating agreement. A couple areas where we see a lot of customization is in managerial authority. What are the boundaries of the manager's authority? What actions can they take without investor approval? What type of investment process, loans, and other areas can they get involved in? Can they designate an investment advisor, including an affiliate, without investor approval? So these are things you kind of need to think about: is what is the managerial authority? What are the limits of that authority? And when do they need to go and get investor approval? And that kind of leads us into the second most important part that's customized: is what are the investor rights? Generally speaking, investors are going to give the manager a lot of authority. They're passive investors, right? But there are certain really important, critical kind of corporate events that should go to investors, such as reorganizing, maybe making material changes to the operating agreement, especially if it's going to affect investor rights, if it's going to be changes to the fees. Those are things that investors are concerned about, right? They don't necessarily want to give the manager the ability to increase fees without a say in that. So really defining what are the investor rights and when does the manager need to go to the investors and get their approval, and what does that approval process look like? The last thing that's important to kind of capture in the operating agreement is the investment guidelines. Again, this is going to be broader than what's going to be in the PPM, but what are the investment guidelines? What rights does the manager have to kind of represent the fund and the investors? What kind of action can they take? Are you going to have some type of board over the funds? Generally speaking, with private funds, you don't have some type of oversight board, but you could. So these are things to think about. Again, managerial authority, investor rights, and investment guidelines. Those are all things that will get customized in the operating agreement. The next thing that you should be thinking about when launching a private fund, generally speaking, you start with your legal counsel because most of the work at the beginning is legal work. That gets wrapped up pretty quickly. In fact, when we've launched private funds, we've done it as quickly as within 2 weeks. We've had a fund out the door, ready to go, investors, marketing materials, everything. I would say that's not the norm, but that in that case, that particular asset manager, they knew exactly what their strategy was. They already had kind of internal documentation. They had a good product plan and project plan in place, and so we were able to execute very quickly. Most of the time, it takes somewhere around 4 to 6 weeks to get through everything and get these things out the door. During that time, though, you need to know who your other service providers are. And the key service providers here are your fund administrator, right? They're going to handle kind of the day-to-day operations on behalf of the manager outside of portfolio management. So they're going to handle things like accounting and investor relations. If you're out raising capital, investors are coming in, they're submitting subscription documents. All of that usually gets managed by the fund administrator. If for some reason, an investor requests a waiver or some other type of wants some other type of customization, which we'll talk about here in a little bit, the fund administrator would reach out to the manager and get them to approve that. Fund administrator is key, and there's some great fund administrators out there, and your lawyer, like us, can help direct you to them if you don't already have one in mind. Probably the next most important service provider is your auditor. So it is required under the new private fund rules that all of these products undergo an annual audit. So hiring the auditor is key. One thing I always kind of recommend to clients is if you think there's any possibility that you might want to convert your private fund into a registered investment company, be careful who you select as the auditor, because during that conversion process, the financial statements need to be in compliance with US GAAP. They need to meet certain requirements, and some auditors are fine auditing a private fund, but they don't do public companies, and they're not necessarily going to follow GAAP when it comes to doing your financial statements, and so that could be an issue later. So make sure you have the right auditor. I've seen situations where an advisor had a couple of private funds, decided to consolidate them and convert them into a registered investment company. We needed to provide financial statements that were GAAP compliant, and they weren't. And when they went back to their auditor to try and get that done, the auditor basically said they weren't going to do it. They weren't going to issue the opinion. They weren't going to help with preparing them. So in this particular case, the client had to go find a new auditor and go back and do the prior fiscal year audit again. So they incurred all that cost. It delayed things by months. So that's just something to kind of keep in mind if you think you might want to convert this product in the future. The last service provider you should be thinking about is your custodian, right? Which bank or qualified custodian, usually a bank, is going to hold the fund assets. Important from a safety perspective, but fairly standard as far as getting the accounts and everything set up with the custodian. So the next area I wanted to talk about briefly was the new private funds rule and kind of SEC compliance. So things that are new, if you've launched a private fund more than a few years ago or had experience with that, what's changed today with the new rules? So the first thing that's changed is quarterly statements, right? Now you have to send out quarterly statements. I think generally speaking, a lot of funds did send out quarterly statements before, but it wasn't necessarily required. It kind of became a good business practice, fairly standardized. Now it's required. I actually recommend that your operating agreement mention that you will be sending out these quarterly statements that specify your obligations, how you're going to prepare and distribute them, and maybe even outlining some of the content in the quarterly statement. The next thing that's kind of changed, again, is the mandatory audit rule, which we talked about. So again, finding an independent public accountant who is going to audit your financial statements. It was pretty standard to issue audited financial statements at the end of the year. It's just now codified in the rule. One of the bigger changes that was not necessarily an industry standard before was kind of restricted activities. So things around like fee practices and borrowing arrangements. Before it was a little bit of the Wild West when it came to private funds and the way that some managers would handle things like fee practices and borrowing arrangements. The SEC has now kind of limited what they can do. So you need to make sure your operating agreement has clauses in that discussing those restrictions and ensuring that the activities are either prohibited by the operating agreement or require some type of disclosure or consent from investors, right? So there are certain things that you can still do, but you have to at least tell investors about it. In some cases, you may need to get their consent. So again, make sure your operating agreement kind of outlines those requirements. The last big change from the rule was kind of this concept around preferential treatment. So one of the common practices with private funds over the past few decades was to have side letters, and certain side letters might give somebody like a most favored nation status. They might get a reduction in the fee. There may be some other clauses in there that favored that investor, and there was really no requirement for the fund and the asset manager to disclose that to the investors. In fact, a lot of times it was intentionally kept secret so that other people wouldn't ask for the same treatment. Now, under the new private fund rule, you have to disclose a lot of that stuff. So either it's prohibited, certain things are prohibited, or you at least have to disclose it. And so again, that should be captured in your operating agreement. When does the manager have to disclose certain preferential treatment? And to the extent out the gate, certain people are going to get preferential treatment. So for example, if you're going to waive the management fee for any employees that invest in the fund, that are still accredited investors, but invest in the fund, not only should you capture some of that in the operating agreement, but you might even want to just go ahead and put it in the PPM so the disclosure is there. So all of your investors are getting that disclosure right away. If something changes after you've issued the PPM and you decide to give preferential treatment, you need to supplement the PPM and you need to give notice to the existing investors in addition to any other potential investors that are looking at coming into the fund. So just make sure all that's captured in the operating agreement, and to the extent it's required, make sure it's reflected in the PPM. There are also some new requirements around advisor-led secondary transactions. I'm not going to go into those in detail here, just mostly because they're limited to specific types of funds. But again, anything related to those secondary transactions should be captured in the operating agreement and also discussed in the PPM if required. So those are some of the key points. If you have other questions, feel free to reach out to us. For the most part, the cost of launching a private fund depends on who you engage as legal counsel. So if you decide to go with a big national brand, expect to pay 6 figures or more. If you're willing to work with a boutique law firm such as FinTech Law or other law firms out there, you can usually pay anywhere from 20 to 30% of the cost of the larger firms. So think about that too. Again, who are your investors? How complex is the product? How fast do you want to get it out? How sensitive are you to fees? If you want to move quickly and costs are important and it's a relatively simple to moderately complex product, boutique law firms like ours are great. We can get those products out quickly. You get a lot of kind of white glove treatment from us, and we'll save you a lot of money. If you're doing things at a global level and you're we do a lot of offshore funds and things like that for clients, but if you're going to be in multiple jurisdictions, multiple different types of funds, maybe different types of feeders, complex strategy, talk with your lawyer about whether they have experience with that and can handle that. And if not, consider whether you need to go to a firm that does. Your lawyer should be honest with you about their experience in those areas and whether it's something they can handle. And if they can't, you really have 2 options. If you like that lawyer and you want to stay with them, they can usually bring in kind of co-counsel to help prepare the documents, or they might have somebody that they recommend that you go work with who specializes in those areas too. So, just make sure that you're having an honest, open discussion with them and they're providing you all the information you need and helping you to achieve your goals. So again, if you have any questions, feel free to contact us. Always willing to chat. And if you're looking at launching a new product, we'd love for you to consider us. Thanks. Bye.